Imagine you are advising a controversial political group. Out of nowhere, the Home Secretary orders the immediate seizure of your client's financial assets, citing a need to maintain the peace. When challenged, the government's lawyers do not cite a specific law. Instead, they claim the executive branch possesses an inherent authority to act in times of necessity, relying on what is known as the Royal Prerogative. But there is a catch. An existing Act of Parliament already outlines a strict court-accrued award procedure for seizing private assets. The Home Secretary entirely bypassed this process. The situation then escalates. Called before Parliament to explain the seizure, the Home Secretary refuses to answer questions from MPs. This refusal is a direct breach of an established constitutional convention requiring ministers to be accountable to the legislature. As legal counsel, you are now looking at a direct three-way clash between a claimed prerogative, an existing statute, and a broken convention. You have to determine which rule prevails. This diagram maps out exactly why this scenario is so complex. The United Kingdom does not have a codified constitution stored in a single document. It operates on an uncodified matrix made up of distinct legal and non-legal sources. To solve our problem, we have to look at how four specific pieces of this matrix interact: Acts of Parliament, case law, the Royal Prerogative, and constitutional conventions. Correctly mapping the hierarchy of these sources is the only way to determine the legality of the state's actions. It is the central task of a constitutional law analysis. Before we weigh statutes against prerogatives, we have to establish the absolute baseline of UK constitutional law. Every action taken by the state must have an explicit legal basis. The ultimate test for this principle was established in 1765 through the landmark common law case Entick v. Carrington. The issue in Entick was the authority to issue general warrants. The court ruled state officials cannot act arbitrarily. They must point to specific legal authority. Finding no statute or precedent, the search was ruled entirely unlawful, rejecting state necessity as a defense. Here is an examiner tip. In an exam setting, do not write vague statements about preventing tyranny. Use the Entick ruling to prove the concept of residual freedom, the principle that citizens are free to do whatever they wish, and the state can only interfere if the law explicitly allows it. Applying this baseline to our Home Secretary hypothetical, the government cannot simply claim a general necessity to maintain the peace. They must prove their authority comes from a specific source, either the prerogative or a statute. The executive branch claims their authority comes from the Royal Prerogative. The constitutional theorist A.V. Dicey defined this as the remaining residue of arbitrary authority legally left in the hands of the Crown. But our hypothetical presents a major hurdle. Parliament has already passed an act dealing with asset seizure. We have to determine what happens when an act of Parliament overlaps directly with a claimed prerogative power. The answer lies in the 1920 House of Lords decision, Attorney General v. de Keizer's Royal Hotel. In de Keyser, the government requisitioned a hotel claiming prerogative to avoid paying compensation, despite the Defense Act requiring it. The Lords ruled, if an act covers the same ground, the statute rules. The prerogative is placed into abeyance while the statute remains. This override only happens if the two sources are inconsistent. In a later case, Northumbria Police Authority, the court allowed a statute and a prerogative regarding law and order to coexist, specifically because their aims did not conflict. Examiner tip: precision in your terminology is vital here. Never write that a statute destroys a prerogative. The correct legal term is abeyance. If Parliament later decides to repeal that specific statute, the old prerogative power revives and becomes active again. Returning to our Home Secretary.
Because Parliament passed an act detailing exact warrant procedures for asset seizure, that statute covers the whole ground. The claimed prerogative is in abeyance, and the executive's shortcut is invalid. This leaves the final complication in our hypothetical: the Home Secretary's flat refusal to answer questions in Parliament, breaching a constitutional convention. To understand the consequences of this, we need to define what a convention is. Marshall and Moody define them as rules of behavior considered politically binding upon state operators, but not enforced by the law courts. The strict limits of a court's willingness to enforce conventions were demonstrated in the 1969 Privy Council case, Mazzimbamuto v. Lardner-Burke. The issue in this case was whether a court could invalidate a UK Act of Parliament simply because the Act breached an established convention, specifically the Convention of not legislating for Southern Rhodesia without the consent of the Rhodesian government. The Privy Council ruled that courts are solely concerned with legal powers. If Parliament passes legislation that runs contrary to an existing convention, the statute is still entirely valid law. A breach of convention does not invalidate a legal act. However, conventions are not entirely ignored by the judiciary. A key nuance emerged in 1976 with the Attorney General v. Jonathan Cape case, involving the publication of the diaries of former Cabinet Minister Richard Crossman. The Attorney General tried to stop the publication by citing the Convention of Collective Cabinet Responsibility. While the High Court maintained it would not directly enforce the Convention, it used the Convention to inform the equitable doctrine of breach of confidence. The Convention indirectly gained legal weight, even though the court ultimately allowed publication due to the passage of time. Examiner tip: you must clearly distinguish between the terms unconstitutional and illegal. A breach of a convention is unconstitutional, resulting in political consequences like resignations. A breach of a statute is illegal, resulting in judicial remedies. In our hypothetical, the Home Secretary acted unconstitutionally by ignoring Parliament. But applying Mazzimbamuto, a court will not issue a legal injunction or remedy to enforce that specific political accountability. We can now bring the analysis full circle and formally advise the political group on the Home Secretary's actions. First, under Entick v. Carrington, the Home Secretary lacked baseline common law authority to seize the assets based on a claim of state necessity. Second, under De Keizer's Royal Hotel, the specific statute governing asset seizures placed the executive's claimed prerogative into abeyance. Bypassing the statutory warrant process makes the seizure definitively illegal. Third, under Mazzimbamuto, the refusal to answer to Parliament is unconstitutional, but it is not a matter for the courts to enforce. The remedy for that breach lies in political pressure. Stepping back from the specific case, you might wonder why the UK relies on this complex, uncodified arrangement of sources that require such intense legal deduction, rather than a single document. The uncodified system provides organic flexibility. It develops in response to real-world events, without requiring complex amendment procedures. This contrasts with codified systems, like the United States Constitution, where rights and structures are deeply entrenched, requiring massive political consensus to alter even a single line. Your final examiner tip: whether the UK should adopt a codified constitution is a popular essay question. Always anchor your arguments in the hierarchy of case law. Examiners want to see objective legal analysis of how the system functions, not personal political opinions. The structure of these overlapping sources creates the check on executive power. Applying this strict hierarchy provides the specific legal mechanism for holding the entire state accountable to the rule of law.